Testing, testing. This is a test of the Seventh Circuit Court of Appeals.
Good morning, ladies and gentlemen. Our first case for argument this morning is Neida against Chicago. Mr. Casablanca.
Thank you, Your Honors. May it please the court, counsel. My name is Jared Casaglad, and I represent Vaughn Neida, who is asking this court to overturn the district court's decision to extend qualified immunity to officers Returno and Enriquez, as well as reinstate the plaintiff's federal malicious prosecution claim. There were additional errors related to mandatory sanctions and the application of the rules regarding judicial actions. To begin, I'd like to discuss the qualified immunity and the probable cause issue related to the arrest of Mr. Neida, and specifically to begin with the clearly established law prong of that issue. The Illinois appellate courts have held that under the animal cruelty statute, law enforcement officers are not free to rely on their own private conceptions of how animals should be treated, and has repeatedly found that the law provides definitive standards for officers to apply in the field when they decide whether to make arrests. And the way that they are instructed to do that is that conduct is only unlawful when it clearly falls within the realm of the prohibited and prescribed conduct under the statute. Otherwise, it is not unlawful because officers cannot decide on their own when it is too cold outside to have a dog, how much food dogs should receive. They must apply the specific and strict requirements that fall within the statute in deciding whether to do that. In this case, the defendants have argued in an effort to make the statute as vague as possible, and in doing so have argued for an unconstitutional interpretation of it, which is at odds with the Illinois appellate court's instructions to them to only deal with conduct that falls clearly within it.
Mr. Casaglad, you aren't disputing that Officer Returno received complaints from Officer Morgan before going over to the location, are you?
To some extent. We're not disputing that she received an email from Animal Care and Control advising that there had been a complaint about inhumane conditions. There is a dispute in the record created by the officer herself through the submission of an affidavit at summary judgment about whether she had additional facts in her possession. But aside from that, no. She did receive a complaint to go investigate at that location about the dog in question.
So it isn't just their own observations that they're relying on here. When they arrived at the scene, they already had complaints, which is why they went there in the first place. Would you agree with that?
That they had a complaint for inhumane conditions that they went to investigate from an anonymous person. And so I would agree that they weren't merely relying on their own observations when they went there and deciding on how to handle these things. However, in deciding whether there was probable cause to believe that there was unlawful conduct, they did apply their own private conceptions about how cold it was outside. And as Officer Returno repeatedly testified, that's why she arrested the plaintiff, because she just deemed that it was too cold outside for a dog. The district court found there was a dispute of fact over whether or not the doghouse that Mr. Neida had built for Macy was habitable. And that really resolves the vast majority of the defendant's claims about probable cause, because that dispute cannot be resolved at summary judgment. And the district court erred by saying that because plaintiff had left Macy in the cold, probable cause existed. Those two things are not reconcilable, where there's a dispute on the one hand of whether the heat in the doghouse was adequate, and on the other, the officer claiming that there was very little heat coming out of the heater that he had wired into the doghouse for Macy to use. So it raises questions because, of course, if officers can simply decide how cold it is outside or it's too cold for animals to be outside, then a citizen who takes a dog for a walk for 30 minutes can be subjected to arrest because an officer has decided when it is too cold. But there's no limitation on that. For example, they can simply decide that a doghouse has to be 2 inches off the ground like they did in this case, even though there is no such legal requirement that doghouses be 2 inches off the ground. So citizens have to know when they're violating the law and when they aren't, and that is why the Illinois appellate court made the decisions that they did about how officers are supposed to apply this law.
Are you disputing that Macy had a choke collar on?
Yes, Your Honor. Both officers testified that no chains were used in connection with Macy.
But that's separate than a choke collar. And we have photographs of the collar.
There are photographs. The photographs that were attached to Ms. Fraterno's affidavit in connection at summary judgment were not the same photographs that were produced in discovery. The photographs in the affidavit are not date stamped, and there's a problem with the photographs that we honestly cannot figure out because of the way that they were dealt with. The photographs were produced in a form, but not in that form. And so while they have produced clear photos at summary judgment of what appears to be a collar around the dog's neck, there's no way to determine from those photos whether or not it's a choke-type collar on its own, where both officers testified that there was nothing wrong with the way Mr. Neida handled the situation. And by not disclosing that defense at any point in time during
I
discovery,
thought the testimony was about the tethering, not about the collar itself. That they weren't disputing the tethering and where Macy was tethered. Not that she wasn't wearing a choke collar.
there's testimony that there's no chains used, and from both officers. But as far as whether or not there is a choke-type collar being used in this instance, it did not arise until much, much later, so there was never any occasion to investigate or ask questions of any further nature beyond what already went on with the deposition.
In fact, during Enriquez's deposition, please correct me if I'm wrong, he is complaining about the way Macy is leashed or attached to the truck, not the nature of her collar.
Right.
Do we have any of the officers at the time of the arrest raising an issue about the type of Macy's collar?
Zero. There's no evidence or testimony or inferences to be drawn from anything in the record related to the collar. And I know that Ms. Paterno testifies on page 280 of her deposition about it, and says there's no chains used. No one ever says anything about the collar whatsoever. And in fact, the defense, or the police in this case, on page 4 and 16 of their briefs, attempt to quote Officer Paterno's testimony about the collar. But, Your Honors, I would submit they took a creative license that's impermissible advocacy in doing so, because Officer Enriquez is not testifying about chains being on Macy as they seem to make it appear. He's actually answering a hypothetical question about whether officers can arrest anyone who leaves their dog outside alone with a leash, because what he said was he had a problem with was that the dog was left alone. And that was the nature of the testimony in the case. So in any event, you have the officers creating their own disputes. They want to argue a defense, but they've testified otherwise. And while there's been some claims that their memory failed during their depositions, which they tried to clear up through their affidavits, it's not clear why that was done some 2 years later on the eve of summary judgment instead of right away if these were really memory failures that caused these things. And I would submit that based on the district court's finding that Officer Paterno admitting that she committed perjury and other inconsistencies in her testimony leaves the court without the ability to believe anything she says,
Well, the court only accepted what she said if it was supported in the record.
Correct. And so she made the requisite findings about the disputes of fact that should have warranted a denial of summary judgment on its own without more. The district court made
On the question of clearly established law, what's your strongest analogous case in which probable cause to arrest did not exist?
People versus Johnson, which is, as the defense raised, an unpublished Illinois appellate court case, and that is a problem.
Clearly established law has to be law established in federal courts. So I repeat Judge St. Eve's question. What is your best authority from a federal court? Federal Court of Appeals, to be precise.
Yeah, I mean, the best
The Supreme
authority,
Court has doubted that decisions of federal courts of appeals can clearly establish law. So your best case would be from the Supreme Court, but if not, from this court.
well, and as far as I know, there's never been an opinion from this court on the animal cruelty statute, but we do cite the Reveal case, which deals with child neglect, and it's different. However, I think that the issue of analogous case law under these circumstances is a red herring, because the statute itself and the Illinois appellate instructions about what that statute means, directed to law enforcement about how to apply it, is enough to clearly establish that The arrest in this case was without probable cause.
Well, don't we have an or here anyway? That you, as the plaintiff, or Mr. Neida, has the option of showing a clearly established law, or that, no reasonable officer confronted with this circumstance would have judged there to be probable cause here.
Yes, and that is exactly the case, because even when we get past the clearly established law about whether a reasonable officer would do it, the question is, what are the undisputed facts that they're relying on in seeking summary judgment? And there aren't any undisputed facts in this case.
Well,
at
that's
all.
not true.
Well,
The undisputed facts that they received a complaint from Officer Morgan
yes.
that it was sub-freezing temperature, that there was no food, that there was no water, either it was frozen over or it was empty. I know there's a dispute about that, but that the dog couldn't get to it. That they arrived there and Macy was tethered in an outside area and nobody was around and it was freezing cold. So none of those are disputed.
And excuse me, you're correct. And the material facts are disputed. And none of those facts
Well, the temperature and the conditions outside, that's very material. And that's not disputed because we know from the record what the temperature was.
I would argue that not under the animal cruelty statute, and section 3.01C directly applies to officers animals in cold weather, and it directs law enforcement officers that you could only arrest someone for subjecting a pet to cold weather when that animal has been injured or dies as a result, or suffers a condition that's been diagnosed by a veterinarian like hypothermia. So there are limits on how and whether you can subject an animal to cold weather, but not making up private conceptions about, well, we just think it's too cold out here. And one of the problems they face and is that they obviously took the dog back into the same cold weather that they are claiming was too cold for the dog, which was not known until after they produced the videos in this case. And they took the dog back into the cold weather. They recreated the scene for the body camera videos that they didn't produce until after the plaintiff's deposition. And as Officer Paterno testified, she stopped and paused to take photos of the dog with Officer Enriquez because she thought the dog looked cute. These are not, the inference from what they did here in hiding that evidence and in doing that is that they really didn't think it was too cold outside for the dog, and that they arrested him for some other reason.
Is it disputed or undisputed that the way the dog was tethered to the truck, he still had access to go inside the doghouse, which was had the heater?
That is undisputed. The officers testified when they first arrived, they saw Macy exiting the doghouse and took a photo right away, and you do see in the photo she's halfway in and halfway out of the doghouse. And so this whole idea that the dog was too cold or shivering or lifting its paws off the ground is disputed because it wasn't too cold for the dog inside the doghouse, and the plaintiff did care for the dog and did clean up after the dog and did do other things that the officers ought to have become aware of. And that's why all the analogous cases talk about issues that are where there's extreme animal neglect, where there's bathtubs full of feces and smells of urine, and dogs with injuries to their faces and front paws and consistent with dog fighting, because these are things where officers observe that clearly fall within the ambit of inhumane treatment.
Mr. Casagrad, can I turn please to the malicious prosecution claim?
Yeah, yes.
What's your best evidence that there's an issue of fact on malice?
The absence of probable cause and the viewing the facts in the light most favorable to the plaintiff. They never really had any concern about the doghouse up until they got back to the police station and started trying to justify his arrest.
How would no concern about the doghouse
Well,
raise an issue of fact on malice?
it's part of the absence of probable cause to believe that the doghouse was inadequate in the first place. They tried to claim the doghouse had no padding, but Officer Paterno admits she didn't check for padding.
Is there any evidence that the officers knew your client before, or there's any history there?
No. There's not.
So no evidence of any kind of personal animosity?
There is not. There is not any sort of personal animosity there. There's simply what the district court found was that there was a argument when Mr. Neida came to proclaim his dog where he challenged her authority and requested a supervisor. And as Officer Enriquez admits, he suggested that they don't have a supervisor. And then they, as you can see from the video, as he was being arrested, his phone falls to the ground because he testifies that Officer Paterno's grabbing it because he's on the phone with a Chicago police officer who's telling him to call for a supervisor. And so you have this clear evidence of a retaliatory motive and malice that they didn't really believe that he had violated any of these offenses. They actually charged him with not keeping his doghouse 2 inches off the ground because they were trying to make up some reason why they'd done this, and they had no good ones. So they invented them. And that became clear throughout the course of her testimony. If there are no further questions, I'd like to reserve the remainder of my time for rebuttal.
Certainly, counsel. Mr. Morrell.
Thank you, Your Honor. And may it please the court. There is just one question that underpins essentially all the claims in this case, which is whether there was probable cause or arguable probable cause for a reasonable officer to believe that Mr. Neida violated the animal welfare statute in some way, when in response to an animal cruelty complaint that said a dog was being beaten and starved, officers went to a seemingly abandoned lot full of broken vehicles and graffiti junk, and on a freezing, snowy day, found a short-haired dog alone, tied to a truck with an apparent chain-link choke collar around its neck, standing in inches of snow, shivering and cold to the touch with no food or drinkable water present.
You say you speak as if it's established that the dog had a choke collar. How was that established?
Well, they're the
It's
only...
certainly denied by the plaintiff.
But denied based on no evidence in the record. The only available...
No, the plaintiff is competent to testify about what kind of collar he placed on the dog from personal knowledge. So what makes the choke collar undisputed or undisputable?
There is no record in the evidence in his deposition or otherwise where he states that there was no choke collar. He's making that argument in his briefs, but that's not an argument that's actually based on anything in the record.
He didn't testify to that?
I do not believe so, Your Honor. The only evidence that's actually in the record as to the choke collar is, to the extent the officer's own statements are irrelevant to the analysis, but also the photographs that show, based on the ordinary dictionary definition, that the dog was wearing a collar.
At the time of the arrest, do we have any of the officers, according to their testimony, raising the issue of this choke collar? I didn't see that in the record.
No. At the time of the arrest, they are not discussing the choke collar. However, as Your Honors are aware, for a Fourth Amendment false arrest claim, what matters is not the officer's own subjective views on why they might have arrested someone in the moment, but whether any reasonable officer could believe, based on the facts available at that time, is there any crime that could justify the underlying arrest. And so here, what the city has put forward, based on the discovery record, is showing that there are at least 5 different provisions of the animal welfare statute, regardless of what was stated in his arrest report, that the evidence shows that he might have reasonably violated. That's failing to provide sufficient food and water, that's failing to provide adequate protection from the weather, unlawful tethering using a choke-type collar, abandoning the animal might suffer injury or exposure, and the quasi-catch-all requirement for owners to provide humane care and treatment. Probable cause for any one of those provisions, or even reasonable yet mistaken belief that there's probable cause for any one of those, defeats Mr. Neida's claims. As the city discusses at length in our briefing, the summary judgment record provides ample basis to justify the arrest and subsequent prosecution. Rather, it is Neida's who fails to satisfy his burden of showing that his arrest in these circumstances was contrary to clearly established law.
Mr. Merrill, why doesn't the testimony that Macy appeared healthy and well-nourished create an issue of fact about her condition here?
So, according to the Illinois Appellate Court, when you have evidence of or observations by officers of inhumane treatment of an animal, they said in People v. Zamora, for example, that the absence of evidence showing that dogs appeared overworked or emaciated or dehydrated does not ameliorate other inhumane conditions. So what the officers are looking for is maybe the dog isn't on...
But this is different than the absence of evidence. This is affirmative evidence that she appeared healthy.
Well, it would be a dispute whether or not the dog seemed healthy to a reasonable officer at that time. Obviously, there was later veterinary report that wasn't information known to the officers at the time of their arrest. But what we see here is that the officers were coming to a situation where they thought a dog was in danger. They found a dog alone tied up with a chain, whether you want to call it a choke collar or not. There was certainly a chain collar around the dog's neck in freezing temperatures, standing in snow alone. And at that moment, the officers, especially against the backdrop of the complaint they received, certainly had a reasonable belief that that was sufficient to believe that a violation of the welfare statute.
I think you just skipped very quickly over what I consider to be an important detail. Standing in the snow alone, I thought, my recollection of the record is this undisputed, that when the officers approached, Macy was inside of the doghouse and emerged and exited the doghouse. In fact, that chain, as we were discussing with Mr. Casaglad, was long enough to permit him to go inside the doghouse and out, in and out. Now, you just said an undisputed fact was when they arrived, he was standing in the cold snow alone.
No, the dog definitely could go in and out of the doghouse. What I'm simply saying was that at this point in time, not only was there freezing weather, but the ground was covered in snow. And as the photos in the record indicate, there was kind of snow and frost creeping into the doghouse anyways, indicating that it was not sufficient to protect the dog from the elements. You know, this was a makeshift plywood structure that had holes in it that wind and the snow could enter it, and you see that in the photographs. So this certainly wasn't a structure that was providing adequate...
I'm wondering if we have more disputed facts here, because another thing that we are able to see from the video is that the makeshift doghouse did not have snow covering the top of it, like many of the other structures and vehicles on that lot. Which certainly creates a disputed fact as to whether the owner was caring for the doghouse, taking snow off of it, whether the heat was sufficient enough to melt the snow off the top of the doghouse. Do you view all that as, non-material facts?
Well, Your Honor, I believe it is certainly true that there was a small heater in the doghouse. There's a dispute about how effectively it worked, but there's no testimony in the record that, for example, as you were saying, that he was taking snow off of the doghouse. I think the time to raise these types of things in the record was during discovery, and none of that was unearthed. But I think what's also important is not only is there the prong, for example, the qualified immunity analysis of whether there was sufficient evidence based on the totality of the circumstances for a reasonable officer to believe there was a violation, but there's also Mr. Neida's burden of showing clearly established law. He does not cite a single animal welfare arrest case, not one, where probable cause was found lacking. Not a single case in all of his briefing, let alone a case with remotely similar factual situations. As just one example, he identifies no case supporting the proposition that finding a dog tied up, alone, without food or water is insufficient to establish probable cause. To the contrary, the court in Manson v. City of Chicago explicitly held that when officers find empty food and water bowls and no evidence of food nearby, such facts alone gave the officers probable cause. Neida's reply brief did not even attempt to respond to our arguments about Manson. As another example, for the prohibition on the use of the choke-type collar, you can see in the photos that there was a collar that meets the ordinary dictionary definition of a collar, and he does not cite a single case nor a single statute that clearly establishes what the law might consider a choke-type collar, and if it's somehow different than the ordinary dictionary definition. Without any such law identified, it is impossible that officers could have very clearly violated clearly established law in this instance. Ultimately,
I'm not sure where you're going. I mean, what I take from your argument is that law is too vague to be enforced. You're saying nobody knows what this means. Choke-type collar, nah, nobody knows. It's a pretty basic rule that you can't enforce a law if nobody knows what it means.
well, I would suggest that what the law means is it's the ordinary meaning of these words. As we provide multiple dictionary definitions and definitions by the Illinois Humane Society where they describe what a choke-type collar is, and that is what you can see in the photographs. But ultimately, for all 5 subsections of the Animal Welfare Act that the officers could have believed that Mr. Neida violated, he fails to provide any on-point case showing that the law was clearly established at the time of his arrest. So while the city does believe that the totality of circumstances easily establishes probable cause, Neida failed his burden, and the officer should be protected by qualified immunity.
Can I turn to your malicious prosecution claim against the officers? Have you raised qualified immunity as a defense anywhere to the federal malicious prosecution claim?
I would have to refresh my recollection, Your Honor, but I believe so. I believe qualified immunity.
See it. I know you did as to the other ones, and I understand at the time the motion to dismiss was filed, we didn't know that there was a federal Fourth Amendment claim for malicious prosecution, and we since know that given the Supreme Court's ruling. But I didn't see anywhere in the record that you raised a qualified immunity defense as to that claim?
Okay, I would have to refresh my recollection, Your Honor. I don't specifically remember. My understanding was that it was raised for all the claims because it was raised additionally for the retaliatory arrest claim and the property seizure claim, but I can't be 100% Your Honor standing here. The only other claim that, assuming there was either probable cause or arguable probable cause for the arrest that isn't automatically disposed of by that one finding, would be that about the property seizure claim where Neida complains that the officers, upon finding his dog left alone in the freezing cold and snow, should not have temporarily allowed that dog to warm up in their parked vehicle. Now, first of all, a Fourth Amendment property seizure claim is ultimately a question of reasonableness, and it was manifestly reasonable to have a seemingly abandoned dog who was left tied up in the cold to warm up in their car while the officers further assessed the situation. And not only was it objectively reasonable, but the Animal Welfare Statute explicitly permits it. In Section 3.01c10, officers are allowed to take temporary custody of an animal exposed to extreme cold conditions. And in Section 3.04, officers are authorized to take possession of an animal incident to arrest. Either provision justifies the officer's actions here, and again, Neida doesn't even attempt to rebut qualified immunity based on either provision because he cites 0 cases in support of this claim.
Let me ask you about the abandonment issue. So we're going back to probable cause. The officers, had a complaint that suggested Macy had been abandoned when they arrived on the scene. Now, when they got there, Mr. Neida shows up within 20 to 25 minutes. And we are to judge probable cause and arguable probable cause at the time of arrest. So they obviously arrest him after he shows up. So he shows up and says, "I'm the owner, that's my dog." Is it your position that the officers don't need to take into account new facts they learned at the scene before they arrest?
No, they do need to take into account the totality of circumstances at the time of the arrest. That said, what was actually said in the complaint that the officer received was that someone who at the time alleged to have multiple animal cruelty complaints, leaving his dog out in the cold 24/7. That's not exactly the same as that that the dog was completely abandoned.
I'm going off of what you just told us. You told us that the officers were confronted with a dog that was seemingly abandoned.
Right. They are confronted with a dog that was tied up alone outside with no one on the property on a vacant lot. And at that time, they believed that the dog there. Now, when Mr. Neida appeared later and said that, that is my dog, they didn't necessarily need to believe what the potential suspect that he was there only recently. Obviously, the officers should have taken his statements into consideration, but that doesn't mean that they need to automatically believe everything that a suspect says in that statement. In fact, later in his deposition, he even said that the reason why he returned was because he got a phone call from a friend that said, "Hey, there's people on your lot," and he was concerned about the vehicles he had left there, not about anything about the dog.
Well, I want to ask you about that too, because the officers, they also got a complaint that it's a vacant lot. And then when they arrive, as we can see from the video, there are a number of structures and vehicles on that lot, most of which are covered with snow. And where the snow has been knocked off of some, they are construction vehicles. There's some nice construction vehicles on this lot. I saw a skid steer and some other things you can clearly see. So it's impossible to tell whether they're operable or not. More facts. I'm wondering whether your position is the officers still believed it was a vacant, abandoned lot.
Right. I mean, by vacant, what I was understanding the record to mean was that obviously there was no structure on there. There was no clear evidence that anyone was living on there except for in a potentially squatter situation. It was fenced off, so public was not supposed to go on there, and it was filled with whether or not there were some vehicles that may or may not be operable. There's no way to know that based on the record. There's certainly vehicles on there with windows rolled down and snow flying into the vehicles and other broken down graffitied structures. I think it's reasonable to believe that when an officer stumbles upon such a lot that it's reasonable that no one is living there at that time.
And there's a trailer on the lot.
Well, once again, there was no one in there at the time of the officers arriving. There's no reason to believe that trailer, like any other of the vehicles on the lot, was being lived in by someone or even functional. The last issue...
What role do you think it plays in assessing qualified immunity that the arresting officer essentially confessed to telling tall tales? The word perjury also comes to mind.
So I do not believe it matters in this instance because, for example, if you look at our statement of facts, there is not a single fact that we cite to that is not supported by, there is no fact that we cite to where the officer's deposition is the sole source of information for that fact. In addition, the officer immediately upon saying that after aggressive questioning, if you read the full deposition transcript, said, well, I didn't, that's not what I meant, I didn't mean to, was not intentional, underpinning that she doesn't really understand what legally perjury means in this instance. But ultimately, as
But she seems to believe that she is justified in telling different stories on different occasions, which does raise the question what facts can reasonably be taken as undisputed. There is a clearly established legal rule against making up evidence to support an arrest or prosecution. Right? You don't have to look hard to find that as a clearly established rule.
Correct, Your Honor. I mean, well, what the city proposes here is that based on the testimony of the other officer present, based on the photographs, based on the arrest reports, based on the information from
I don't see how the arrest reports can be believed, given the fact that this officer confessed that they were not necessarily true.
So when we're assessing probable cause for a Fourth Amendment claim, ultimately what we need to consider is what a reasonable officer in that position, not what the individual officer believed. The question for this court is ultimately whether or not, based on the record that we do have in front of the evidence that is undisputed, then the question is whether that evidence is enough for a reasonable officer, not whether this subjective one officer believed that there was grounds to arrest. So, for example, the arrest report does talk about the 2 inches off the ground of the doghouse. Now, that is not necessarily sufficient basis on its own to support an arrest, but it is evidence that the structure was insufficiently protecting the dog from the elements. And here, it ultimately doesn't matter that they wrote that one factor into the arrest report, because we have all this abundance of other evidence that when doing it from an objective perspective, what a reasonable officer in that position might know, then we have sufficient evidence here. So again, I just would reemphasize that what's relevant here is not the officer's subjective views about what or what not justifies an arrest, but based on the record evidence, what is for an objective, prudent officer might reasonably believe, and then in the qualified immunity context, maybe even mistakenly believed, but reasonable nonetheless because the law is not clearly established at this time. I think it is extremely probative that the other side has failed to put forward even a single false arrest case under the animal welfare statute where probable cause was found lacking, especially in anything that's even remotely factual with similar situations. Therefore, qualified immunity should govern in this instance.
What's your strongest argument that there is an issue of fact, that there is not an issue of fact on the malicious prosecution claim as to whether the officers acted with malice?
Well, in this instance, the fact that there is probable cause is the basis that the city is putting forward.
The district court did not make that determination. The court only made an arguable probable cause, which wouldn't be sufficient.
Well, the district court on the malicious prosecution claim did not actually reach that at the summary judgment stage.
Correct.
Yeah, they only reached it.
But you're asking us to address it here.
Correct, because all of the evidence, there is no dispute, and certainly Mr. Neida, none of his briefing says there is a dispute, that there is any evidence that he would have put forward that was not discovered during discovery for the question about whether malicious prosecution. Here we had the state malicious prosecution claim, the federal false arrest claim, both of which deal with probable cause analysis. So there was every incentive and every opportunity, and there was, in fact, all that evidence presented to the district court. And so simply this is just an alternative ground now that all that evidence was
His
presented.
argument is that the best evidence of malice is that there's no probable cause.
Correct. I mean, certainly in this case, there is no, as you were discussing with opposing counsel, there is no evidence that the officers knew them or that knew Mr. Neida or had any
lack
ill
of
will.
probable cause, being arrested without probable cause?
Yeah, but if you're arrested with probable cause, then the malicious prosecution claim obviously fails on its own.
Right, but that's he's saying there's no probable cause,
Correct.
and I'm asking you because we can't rely on arguable probable cause for the malicious prosecution claim. So how would you respond on the record before us to the malice element of malicious prosecution if we can't determine probable cause?
Well, I think the burden here would be for Mr. Neida at some point in discovery to put forward evidence of malice, which he has none. So there's just simply no evidence in the record that the officers had any malice in this instance. That should have been something that he pursued during discovery.
Are you saying lack of probable cause isn't sufficient to establish malice?
It would probably be sufficient, is correct, Your Honor, to sufficient to evidence malice at this stage of the proceedings. If Your Honors have no other questions, for these reasons, the judgment of the district court should be affirmed.
Thank you, Mr. Morell. Anything further, Mr. Casablad?
The district court also made a finding in response to plaintiff's summary judgment motion on probable cause that a dispute of fact existed over whether probable cause to institute the charges existed. She dealt with this issue. The city did not appeal that issue, and that was a finding made by the district court in the record already. There's also...
I'm lost. Why would the defendants need to appeal anything?
Because there's already been a determination based on the evidence.
No, look, you need to address a legal point that the people who prevailed in the district court can defend their judgment on any preserved ground without needing to file a cross appeal. That's just a legal rule.
Whether or not they appealed.
They do not need to appeal.
Excuse me, I may have miscommunicated. I'm trying to say that the district court addressed the issue already and made a finding that there was a dispute of fact about probable cause, which exists.
They do not need to appeal in order to dispute that finding.
The city also argued that there's no evidence of malice.
I think it would be a good idea for you to address the point, the argument made by your adversary, that there is no evidence in the record that that the dog was not held by a choke collar, right? What Mr. Morell said is that there is a denial in papers, but nowhere through evidence. Now, is that true? Or if it's not true, what evidence do you point to?
I would point to the testimony by both officers that there were no chains used by Mr. Neida. And they're not just talking about the leash.
All right, you're not pointing to any evidence from the plaintiff.
The plaintiff was not asked about the collar.
It's fine. You can file an affidavit, whether or not you're asked. But I take it it's now agreed there is no evidence from the plaintiff on this point.
Yes.
Okay, thank you.
I would agree that the plaintiff did not testify about the collar. But the question that it raises is why, if they were going to raise the collar at summary judgment throughout the course of the case, did the defense not say so in the answer or in the interrogatories where they were directly asked for the factual basis on which they believed they were going to try to claim summary judgment for Mr. Neida's arrest? And they didn't disclose anything until later on at summary judgment when they filed an affidavit from their own officer trying to change her testimony to expand the record to make it seem like all along she believed that she got a complaint about a beaten, abused, terrified dog, which was just not the case according to her own testimony, and it didn't arise until then. And it raises serious concerns about how it is that this officer's testimony was changed at that time and why it was changed then. If not to just...
That affidavit didn't address the collar, though, did it? It just addressed the summary reports.
It did. It attached the photographs that were the basis for the argument about the collar, which is one of the problems with what has happened here, is if, there's... So, I would also say that the concern about... Well, I actually don't know what I'm going to say next, so I'm going to stop pretending like I know. If there's no further questions, I would rest on what we've already argued. Mm-hmm. Thank you.
Thank you very much, counsel. The case is taken under advisement. Our second case for argument today is direct supply against the United States.
Ready?
Mr. White.
Good morning, Your Honors, and may it please the Court. My name is Barry White, and I represent the appellant Direct Supply. The issue presented in this case is whether direct supply is entitled to a tax deduction under a now repealed section of the tax code, Section 199. Section 199 was designed to encourage the domestic manufacture of certain types of goods, and software is specifically identified as one of those types of property that can qualify for the deduction. Direct Supply manufactures a software product known as DSSI. DSSI is e-procurement software, which is a type of software that automates and integrates an organization's purchase of products while making only certain products visible and orderable by employees in the field, automatically, electronically transmitting purchase orders and invoices, implementing various controls, and capturing data that the organization can then use to analyze and help control its spend. I want to talk about three things here today. First, I want to talk about why the district court erred in denying Direct Supply's motion for summary judgment under the plain language of the statute. Second, I want to talk about why the district court erred in denying Direct Supply's motion for summary judgment under the so-called third-party comparable exception contained in the regulations. And third, I want to talk about why the United States wasn't entitled to summary judgment even if Direct Supply was not. So first, let me turn to the statute. Section 199 provides a deduction for a portion of gross receipts derived from a lease, rental, license, sale, exchange, or other disposition of software. So the questions under the statute are whether Direct Supply licenses or rents DSSI under its contracts with nursing homes and suppliers, and if so, whether Direct Supply derives revenue from those licenses or rentals.
How do you get around the language in the contracts that the transaction fee here is in consideration of the provision of transaction services?
I think that,
And 95% of the fees here at issue are derived from the transaction fees.
I think the answer to that question, as I cited these cases in my reply brief, is that the court needs to analyze the substance of the transaction. And
Well, that's a piece of it. The contract itself says these fees are for transaction services. It doesn't say it's for the license of the software or the use of the software. It talks about services, which would not be covered under Section 199.
Well, I think what you need to do is apply a textual application of the statute. I do agree that the United States has taken sort of this shorthand characterization and said, if you're providing services, it can't qualify for the 199.
It's not if you're providing services. It's if you are charging for the services. I mean, you could provide services, but if the fee is for the service, then the fee is the revenue here. Then the revenue would not be derived from the use, the license, the sale, or disposition of the software. It's coming from the service.
I think, again, that we know parties can't contract around the tax law. And so we have to look at the structure of the contract. And I do agree that the contract does say that. It says what it says. But the structure of the contract is such that the revenue, I do think, is derived from this permission to use DSSI, which I believe is a license. And the reason I think it's derived from, which means it flows from, is the structure of the contract in return for being granted permission to use DSSI. The contract requires nursing homes to use it for all of their procurement needs. And it's that use that then generates the fees. And so the fees are derived, they come from.
It's the purchase of the products sold from the supplier that generates the fees. And the evidence is even undisputed that the fee amount is directly related to that value of the product. And how do you get around that? That the fee then is for the product, the service connected to the product, not for the software.
When the software is the is what customers are paying for. Is what customers seek out. And they are required to use it for 100% of their procurement needs. It's that requirement of use that then results in all of the fees.
Why
And
wouldn't
that
there
is
be
why-
a flat fee then? Why is the fee connected to the value of the product?
I think that's just a pricing model that Direct Supply chose to pick, presumably because it makes it easier to market or it maximizes dollars. But I think, and this is the important point, Judge, I think that if the contract had said, customer will pay X dollars for, per year or per month for a license of the product, I think you'd still have to do the same analysis. I think you'd still have to apply the text of the statute because I don't think that the parties' terms of their contract are necessarily dispositive of a tax issue. And that's why I think you
Well,
have
sure
to...
they are. Those are the facts. The statute may tell you whether or not they have to pay the revenue, but you have to look at the facts to determine if they fall within the statute.
We can't, in a contract, say that we can't contract around the tax code. We can't say if that this payment is for a license. If the court then takes a look at the contract and says, I don't agree, that isn't correct, you're not going to give us the tax deduction simply because we said it in a contract.
No. But you certainly have control of your own pricing models.
Sure.
And you told us as much in your brief. And I'm trying to understand why footnote 10, which starts on page 32 and goes to 33, doesn't actually just throw your own case for you. You say, presumably, if Direct Supply had chosen a different pricing model, and its contracts had said Direct Supply hereby grants a licensee a non-exclusive license to use DSSI for 1 year for X amount of dollars, there would be much less controversy. We wouldn't be here. And that seems to be true according to everything you're saying. If Direct Supply had chosen a different pricing model, it certainly might have had the benefit of this tax deduction. But Direct Supply is in charge of the pricing model that is chosen. It's chosen this alternative one, and this alternative one doesn't seem to me, even by your own concession in this footnote, to fall within the plain language of the statute.
Well, again, my contention is that the structure of the contract, which requires use, in return for being given permission to use the product, in return for being given permission to use DSSI, you have to use it for all of your procurement, and that use generates fees 100% of the time. I think that regardless of what the contract says, and this is the point I was trying to make in my reply brief, that regardless of what the contract says, you still have to do the same analysis under the statute and say, are these fees derived from? Now, maybe it would have been an easier answer, an easier conclusion for you to come to and say, okay, well, yeah, the contract says it, so I agree that these are derived from a license. But I don't think the fact that the contract doesn't say that is necessarily dispositive. You still have to look at the structure of the transaction.
The facts show that the fee is tied to the value of the products, not to accessing the system online.
Well, it's tied to the amount of use of the products,
Not the amount of
DSSI.
use, it's tied to the value purchased from the supplier.
Right, which depends on use. The more you use it, the more you buy.
No, it depends on what you
pay.
buy. It depends on the volume of what you
Right.
buy. You could go on for 1 minute and charge $100,000, or you could be on for 5 hours and charge $10.
Right. Well, no, that's
so
true.
it's
but
not.
that's,
It's not. Just let me finish, please.
Of course.
It's tied to the value of the product, and that is undisputed.
It is undisputed. But again, you have to use it for all of your purchases. And so you can't just buy one thing with it. You've got to buy everything with it. And it's that requirement that to my way of thinking, means that the revenue, the gross receipts, are derived from that permission to use. Because in order to get permission to use, you have to agree to use it for everything. And that's what I think derived means.
But there's. Go ahead.
But, it's just, that does not seem to be what Congress and Treasury were doing, because under your analysis, basically any online software that we all use would then be available for this tax deduction. And seems to me they took great care, because we all use online software for different things. And they took great care to separate out online software, the narrow circumstances in which it would be used.
I think what's problematic is that software is difficult. that because any interaction online is powered by software, right? So you're talking, I think, about any time we use an online service, maybe banking software, that is certainly powered by software, and that is intended to, Congress didn't intend to provide a deduction for that. But there's a fundamental difference with a software product like DSSI. DSSI is sought out by nursing homes for its functionality, for the features that it provides.
How is this any different from Amazon? Amazon is sought out because it provides access to a large catalog of goods. But if I understand your argument correctly, Amazon can deduct its entire gross income because all of the gross income is facilitated by the software underlying its website. Does that seem remotely plausible?
No, and it's not plausible, and it's not my argument. And
I'm not saying it is your argument, but it is the logical implication of your argument.
I don't think so, and I think not for two reasons. First, there's no requirement to use Amazon exclusively for all of your purchases.
I
and I think
see
that's
why that is relevant.
I think that's what makes...
When you do use Amazon, you are using the software underlying its web engine. Every time you use Amazon, you're using that software. And therefore, the logical implication of your argument is that all of its gross revenues is payments for use of its software, even though 98% of its cost is the cost of goods. That looks pretty much inevitable if we accept your argument.
Well, I think there's a distinction between software that is a product, software that one wants to use because of the software, like DSSI, or like Microsoft 365. Microsoft now is available online. You don't actually put it on your network anymore. You log in and you use Microsoft Word. That's a product that is sought out. That's very different than the behind-the-scenes software that powers Amazon. The behind-the-scenes software that powers Amazon is meaningless to the consumer. The consumer doesn't go to Amazon because...
The consumer doesn't care about the behind-the-scenes software that powers direct supply. It cares about getting what it wants to order.
No, I don't agree with that at all.
Consumers don't care about that.
I believe that direct supply DSSI is a software product that people seek out, not just to buy, and we know that, Judge.
Can you explain to me why Amazon can't make the identical argument that people seek out its website because it's got this great software that facilitates the purchases?
No one enters into a contract with Amazon for Amazon to create software to what people do with Amazon is sign up for Amazon. They're not seeking a particular product. And we know this is a software product because we know that there are competing products that you can download and put onto your network. We know there are at least 5 of those, and it is a product that companies go and seek out. One seeks out Amazon for what Amazon does for you. They don't seek out the particular software.
Mr. White, I agree with you that Microsoft 365 is the better analogy, but it seems to me the issue is how direct supply is making its money off this software. And we were talking earlier with Judge St. Eve about the facts. How do you get around other facts in the record that direct supply's own witnesses testify, for example, that the maintenance fee is for service, it's not for the software, that direct supply does not charge for the software?
Again, I think that direct supply, those aren't judicial admissions. He wasn't asked the particular question about does direct supply derive gross receipts from a license or rental. Likewise, under the third-party comparable, I just want to touch on this because I see I'm almost out of time. What I want to touch on is that on the third-party comparable, the argument on access to the software is the same. The requirement to use is what makes the fees payable for access. You don't get access unless you agree to use it for all of your purchases, and those purchases are what generate the fees. On the second component of the third-party comparable, the requirement of substantially identical software, the record was clear. The government didn't dispute that there are 5 products that were available on a disk or by download, and that those 5 products meet the definition of substantially identical under the regs. What they challenged was one declaration from our expert, and that would be an issue that would need remand, along with the motion to supplement the record, which would need remand on the third-party comparable exception.
Thank you, Mr. White. Mr. Dale.
May it please the court. My name is Ivan Dale on behalf of the Appellee United States. The conclusion that the fees paid to direct supply are not domestic production gross receipts, which would give rise to a deduction under Section 199, that conclusion is demonstrated by the contracts into which direct supply entered, direct supply's testimony from their own officers about what the fees come from, and the implementing regulation implementing Section 199. So the contracts, I want to make clear, direct supply doesn't just process transactions, and it's not just, the services it provides are not just interactions with software. You know, they provide a part-time implementation an analyst to enable the customer to go live, an assigned integration analyst to monitor and test all data feeds. The nursing homes get access to a wide range of suppliers that have contracted with direct supply, to which they may not have otherwise had access. There's an assigned specialist to manage the product catalog and build up the catalog of products which can be purchased. There's in-person training, there's project management. If there's a dispute between nursing homes and their suppliers about a particular transaction, direct supply adjudicates that dispute. There's a maintenance of a database containing order transaction information. That's storage. That's hardware, not software. So, you know, it's not even just a characterization in the contracts. Although I would argue that when you're talking about matters of a contract, you're talking about things that direct supply itself has agreed to be bound by, and it's not just a label. Direct supply has agreed that it's, you know, that the fees are specifically in consideration for the provision of many of the services that I just named, and both with providers and suppliers. And as the court noted, you know, direct supply's vice president of sales, Kevin Doherty, was asked directly, and I don't. This is almost exactly parroting the statute. Do you charge providers for using direct supply software? He answered no. And then he was asked, do you charge suppliers for accessing direct supply software? He answered no. Andrew Novotny, direct supply software engineer and team leader, testified specifically, we do not charge providers for the software. Any fee charged nursing homes was, quote, not a license for the software, but a fee to cover our costs for maintaining the system.
Mr. White says those are not judicial admissions. How do you respond, if you know what that means?
Well, what they are is unrebutted evidence. They aren't in a request for admission, but it was in a 30B6 deposition. We asked direct supply to you know, identify someone that can speak to how these fees are charged, and they produced, you know, these gentlemen, and they testified that, you know, that any fees charged suppliers was, quote, not for the software, but for the transactions.
And that's consistent with the contract.
And that's absolutely consistent with the language of the contract.
I don't think there's anything, at least I didn't see anything in the contract itself that suggests the fees are for licensing or otherwise of the software.
Correct. I don't see the word licensing anywhere in the contract. Well, I do. I actually do see the word licensing in the contract when it refers to the suppliers agree to license, their logo and license their product information.
But not in connection with the
Right.
fees.
Not software.
Right.
So clearly, Direct Supply knows how to call something a license. It's words in their contract, but nothing with respect to licensing software. The regulations themselves make clear that this is not a license or other disposition of software, and I think the prototypical example on the one end of an online access to software is Microsoft Office 365, the suite of products that you get. And in that case, you pay a subscription fee in exchange for the software. It's monthly or annual. You do download something onto your computer, so there's a transfer of software that at least enables you to interact with Microsoft. There are parts of that suite that are not licensing software. For example, it gives you access to Microsoft OneDrive, which that's storage, that's hardware. And the preamble to the regulations discuss how storage does not meet that threshold. So there are circumstances. In fact, there was another software involved in this case, the TELS software, and the exam team looked at it and decided, yes, this does meet the requirements for the deduction, because again, there was a monthly subscription fee for the building management software, and it was usable as a standalone, interaction with the software for its own ends. These Direct Supply's procurement system requires counterparties. I mean, nothing happens unless there's two parties to the sale. So it's not at all like Direct Supply, or it's not at all like the Microsoft Office suite of products. And it is, as Direct Supply touts in its own advertisements, it is like an Amazon.com style virtual marketplace. So in the end of the day, the statute and I was going to mention also the regulations talk about online auction software that is virtually on point to this kind of thing, and there's a transaction fee charged in the online auction software. So, and I think Your Honor is correct to point out, like, if you're interacting with, if you want to buy something on eBay, you have to interact with eBay software. So the fact that you have to use the software to engage in the transaction really just opens it up to almost any interaction with e-procurement software that is at least developed in the United States. Any e-commerce software that is developed in the United States. So, Direct Supply service is very much like the brokerage service in BATS, the 10th Circuit case. It's very much like the auction house in example 2 of the regulation, neither of which gives rise to domestic production gross receipts. And nothing in the evidence compels a different conclusion. Unless the court has any further questions, I would just ask that the decision of the district court be affirmed as correct. Thank you.
Thank you very much. The case is taken under advisement. Our next case for argument is SEC against Equitybuild, the appeal of BC 57. Mr. DeVaught.
May it please the court. My name is Andrew DeVoe and I represent BC 57, the appellant in this matter. Your Honor, may I please reserve 5 minutes for rebuttal time? This case involves the recognition of two distinct legal concepts. First, when the debt secured by a mortgage is paid, the lien of that mortgage is extinguished as a matter of law and unenforceable. Second, when such a debt has been paid, pursuant to the Illinois Mortgage Act, the prior mortgagee, upon request, must draft and deliver within 30 days a release of record evidencing that payment, which can then be publicly filed to aid owners and lenders in keeping the chain of title. These concepts do not conflict, just the opposite. They work together to help ensure the free alienability of land and the clarity of title in the real estate market. But the district court erred in this case by concluding that the Illinois Mortgage Act replaced the common law rule of extinguishment, such that a mortgage lien, regardless of whether that debt securing that lien had already been paid in full, remained enforceable until a release of record is requested and delivered. There is no support in the Illinois Mortgage Act itself, the legislative history, or the relevant case law to support that conclusion. Just as importantly, we have the unique opportunity with the Illinois Land Title Association and their real-world perspective from 100 years participation in this field, confirming the coexistence of these two distinct legal principles, and similarly forecasting far beyond the scope of the parties in this case, problems and disruptions that could result in the real estate market in Illinois if the district court's ruling is upheld.
What are we to make of the Illinois appellate court cases that I know aren't controlling, but that talk about the act and find that essentially common law hasn't survived, like North Shore and some of the other cases?
Yes, Your Honor. So I think North Shore holding is best understood as limited to the effect of the lack of the delivery of that release. And I've submitted the briefing in the separate appendix, Your Honor, so you could see the briefing of that issue. Blue Water and Premier were the two entities, and the main issue in the case was about a mechanics lien. But the initial issue was whether or not North Shore, the bank, had standing because the mortgage had been paid and a release had been executed but not delivered. And they relied on the Illinois Mortgage Act for this notion that payment meant that then there was an automatic release. But, Your Honor, respectfully, I don't think that decision reached the question here because there was no consideration of the common law, no one cited it, no one discussed it. And this is in 2014, 2 years after the Illinois Supreme Court had decided Rush University Medical Center, where we cite in our brief, lays out the clear rules for the appellate courts in Illinois, not the Seventh Circuit, but for the Illinois appellate courts to follow whether or not there was legislative abrogation. And there was none of that analysis, Your Honor. And I think it was likely the way that the issue was presented to the court, but it just didn't, I think it's best read as not reaching that issue.
Can I ask you about another case that was 14 years before the one that you just cited? It's Coupier, or Coupier, K-U-I-P-E-R, Illinois Appellate Court in the year 2000 saying, until such release is filed, the mortgage lien remains in effect. And goes on to hold, because no release of lien had been filed, pursuant to Section 2 of the Mortgage Act, there was no indication to third parties that the lien was ever extinguished. So it seems to me we have the Illinois Appellate Court in 2000 looking at the interplay between the Mortgage Act and the common law and saying what the individual investors are claiming.
Your Honor, I think that in this case where you have, again, but there's no analysis there. I would say that the common law has been overruled. I think that what's important here is that in this instance we have a law going back to the 1800s, and there's been no attempt to actually reconcile. I think often what happens is there's this conflation, as we have with the appellees, respectfully, that a conflation of the concepts that the release of record, and partly because I know the term release is tossed around in so many different contexts, but the release of record is documenting what has already happened. And there's a conflation of the two that...
But the release at issue in that case is specifically talking about the release of the mortgage. It specifically says that remains in effect unless the release pursuant to the Mortgage Act.
Yes, sir. And I don't have that case in front of me, and I can address that in rebuttal. But I think that the case that the plaintiffs have, or excuse me, the appellees have primarily focused on with North Shore, it clearly cannot be held for the proposition that it has been, that the common law has been superseded. And I think primarily, Your Honor, that again,
Why isn't it? While it may not be controlling, I agree. Why isn't that at least persuasive for us of where the Illinois courts are going?
Your Honor, I think because it hasn't engaged in any attempt to reconcile the two. I mean, there's no attempt to look at the statute, to look at the framework. Properly understood, the framework of the statute fits hand in glove with the common law. The common law and the notion of the common law is the idea of the extinguishment of the lien.
I think that's exactly what this Couper case does do. So you'll be able to take a look at that. But let me ask you this. Do you have a case after 1961 that says what you need to say, which is that mere payment extinguishes
Yes,
a
Your Honor.
mortgage lien?
Yes, Your Honor. So Dunas from the First Circuit, First District, 1963. Similarly, Your Honor, and I think that's noteworthy because Dunas is in the First District, which is where the North Shore case was decided. Similarly,
That sentence, you're going to point us to a sentence in Dunas, right? I'm trying to understand why that is not dicta here. Go ahead. Let me hear what you're going to say about Dunas that's different from what you've said in your brief.
well, no, Your Honor, I think it's just pointing out that you have a case 2 years after the enactment of the Illinois Mortgage Act, specifically relying on the Illinois Supreme Court's decision in Marcus. And so from 1940...
But Simos didn't talk about the act at all.
No, Your Honor, it did not talk about the act. And
Perhaps
that's-
because the transactions predated the act.
Yes, Your Honor. And so...
All right, so let me rephrase my colleague's question. Do you have any Illinois case after the act where the transactions themselves occurred after the act?
Yes, Your Honor. So Rockford versus Rios is a case from the Illinois Appellate District where the court specifically found that where the subsequent holder of the mortgage had paid the underlying lien, that even though it went to Roe, which was the servicer, and did not make it to Rockford, that in that instance, Rockford was not entitled to foreclosure, and that the subsequent financier was entitled to a release. And that's consistent with the common law rule. So
But the Rockford case certainly suggests that the release, that absent the release there, that the mortgage was still in effect.
Your Honor, but the premise in the trial court was that the bank couldn't foreclose because the debt had been extinguished, such that the lien had been extinguished. That's the holding of the trial court. And then on appeal, that case focused on the notion of the money going to the servicer instead of to Rockford. And because just like here, where the servicer was expressly authorized, as the district court found with respect to Equitybuild finance, that the servicer received those funds, and therefore there was no duty to look past the money payment to Roe, the servicer, versus the money going to Rockford. And that's exactly what happened here. In this case, under the common law, BC 57 paid the underlying debt of the investor-lender's mortgage. They paid it to Equitybuild Finance, the express agent, for payment purposes.
Is there any evidence that anybody with your client did any due diligence on Equitybuild or Equitybuild Finance?
Yes, well, so first of all, yes, Your Honor, they did take steps in this case in terms of, hiring the title insurance company and acting as their agent. They had their lawyer going through. They looked at the underlying records, which is what you would do on inquiry notice. And I think that's a really important point document number 1118, which is filed by the receiver, explains that if the court, it files the Fraudulent Transfer Act and its claim, those sorts of issues will be squarely addressed, as Judge Shaw noted, on the notion of inquiry notice, if this court were to determine that BC 57 has priority. But as the receiver said, those are issues that would be achieved at that time. And that would be an analysis the court could take. But Judge Shaw specifically did not reach that issue of inquiry notice. And so I think that most important here are the Section 9A of the Collateral Agency and Service Agreement, specifically authorizing issuing the payoff statement and specifically authorizing the Equitybuild Finance to receive that payment. And pursuant to that common law rule, that was an extinguishment of the lien. And therefore, the only lien that remained was BC 57's lien. And I just want to go back to, with the Illinois appellate courts, again, when you look at the framework of this statute, I also want to point out the Illinois Supreme Court has told us, under Rush University Medical Center, that when looking at a statute, if the common law provided greater protection than the statute purports to provide, but that there's not tension between the two, that it's better to find that they're consistent and the statute is effectuating that protection. And that's absolutely here.
I think you've got a real dispute on that here, though, because BC 57 is arguing for a world where someone can pay off the debt and nobody will know.
Your Honor, respectfully, that I don't believe that's true. And the receiver says we're asking for a war we can just pay anybody. That's just not true. In this instance, it's clear, and Judge Shaw didn't agree, he agreed, pages 15 through 17. And the appellees admit on pages 18 and 19 of their brief that there was authority for Equitybuild Finance to issue, it's the critical one point of agreement, I think, on this issue, that there was the express authorization to issue the payoff statements and for Equitybuild Finance to receive the payment. So, Your Honor, we're certainly not asking for this notion of can pay anybody. And the notion of diligence and the like is an issue that will be addressed on inquiry notice. There's no question. But the receiver has said that issue is moot until deciding the issue of priority in document 1118. So that critical agreement on the issuance of the payment. But the protection of the common law, Your Honor, it followed the money. If someone paid the debt underlying a lien, that lien was extinguished. And now, if the appellees are right, then the Illinois Mortgage Act, the protection afforded to that same party, is that they could pay the underlying debt, and they're completely at the whim of the prior mortgagee for up to 30 days. And the only protection is you could go to court and pay $200. And it was actually $50 in 1961. It's an administrative complement, properly understood looking at the framework. And furthermore, it's only upon request. So respectfully, as being on request, if a mortgagor, an individual mortgagor of a house, as the ILTA features, doesn't ask for one of these release of record, which is memorializing what happened, then the idea that they wouldn't be protected, that conflicts with the notion of what the Illinois Supreme Court has told us. I similarly, I just want to touch briefly on, in terms of the releases, I don't think this court has to reach this issue, but if you were to reach the issue that the release records are necessary, there was authority here. The documents don't render each other superfluous. The collateral agency and servicing agreement says that you need written instructions for a termination, an amendment, or foreclosure. In this instance, the authorization document, these are in a packet of materials in Exhibit 14 for document number 1160. And when you look at those, they're a packet of materials and they're separate documents. The authorization document that Judge Shaw analyzed, and there's a sample of it on page 19 of his opinion, that document is a separate document effectuated, and it specifically provides authority regarding one specific task. And that is to...
We don't even need to get there, though, if we agree with the district court that the releases themselves were not facially valid, do we?
That's correct, Your Honor. And I think, and it's one point I would briefly address, is just that when you're looking at that in our arguments regarding Scrivener error, every document in this case, the collateral agency servicing agreement, the authorization document, the mortgages themselves, the promissory notes, they all demonstrate the relationship is between the investor lenders who had complete transparency.
But what about the contrary evidence? And it's your burden to establish this by clear and convincing evidence. What about the contrary evidence showing that Equitybuild, not Equitybuild Finance, was in fact issuing the releases, and the fact that the original payoff letters directed your client to send the payoff directly to Equitybuild? In light of that, and the equitable nature of this proceeding, how can we find that the district court erred?
Your Honor, so first, taking that one specific example, in that email thread, that error was corrected, right, as a part of the process. I think hindsight's a powerful tool, right, in the context of a case like this, looking back.
It sounds like you're asking us to reweigh what the district court.
No, Your Honor,
relied.
I think it is true that abuse of discretion, I think, applies to the last component with the releases. I think that's right. I think the others are questions of law. I agree and acknowledge that that is abuse of discretion. I think what I just point Your Honor to is that every contemporaneous document that the investors had total transparency to demonstrated this relationship. And that error about whose name was on there was corrected. They also fully understood the relationship, respectfully, the investor lenders understood the relationship between the borrower and the servicer. And there's unrebutted expert testimony that that's not uncommon in this industry. So I just would say that when, Your Honors, when you look, you have this unique perspective of the ILTA that is unrebutted by the appellees of how everyone in the industry understands these things to work.
Thank you, counsel. Mr. Stein.
Good morning, and may it please the court. I'm Max Stein, one of the attorneys representing the certain individual investors. I will be addressing the arguments about the effect of the release at issue in this appeal, and my co-counsel, Mr. Augenlicht, will be addressing the arguments regarding the Illinois Mortgage Act. I'm going to go off script here a little bit and jump to the last point my opponent just made. He makes a big deal about the fact that the title insurance industry, has filed an amicus brief here and that it is unrebutted. It is also entirely self-serving. And in this case, in the event that the district court's ruling is reversed and BC 57 is held to have the higher priority lien, then the title insurance industry will be off the hook. And while that's not a relevant consideration for determination of liability, here in this equitable receivership, that is an appropriate thing for the court to weigh. And so the word of the title insurance industry should not be taken as some sort of wisdom from on high, but rather as the self-interested words of the industry that is trying to defend what Judge Shaw correctly noted was sloppy practices. Because that's the other thing I want to address. The record here is clear. BC 57 had the opportunity to do due diligence, and it completely failed to do it. It completely failed by first outsourcing that due diligence to its title insurer and then relying on that title insurer entirely. BC 57 did nothing to find out about the source of the authority upon which it now relies. My opponent talked about the servicing agreement and the authorization document.
Is there any evidence or any suggestion here that BC 57 knew of the fraud that was going on?
Knew of the fraud? No.
Yes.
But
Okay.
it did know that there were documents out there that it did not even bother to ask to look at. And
Is
it
there
did know.
any evidence that your clients knew about BC 57?
No, there's not, Your Honor. And I want to go, the servicing agreement and the authorization document. BC 57 never saw them. Its lawyer didn't see them, its title insurer didn't see them. Just did not bother to look at them. Now that it finds itself in this equitable receivership, it is relying on those documents that it never saw and claiming that those documents somehow granted rights that the documents themselves don't even actually grant. The authorization document does not give authority to release the liens. First off, I want to give credit. The authorization document doesn't even bear that title. That's a bit of clever rhetoric that BC 57 used, and it stuck. But in reality, that single piece of paper at one page in the loan packet has no title and primarily serves to memorialize the amount of the individual investor's investment and how much of the mortgage that investment equates to. That's what's at the top of that document.
You know, I take the district court on that point. He can't go quite where BC 57 is going with titling this document, but can't quite go where you are either, saying the primary purpose of this document is the stuff at the top when there's this clear language at the bottom.
There is that
so
clear.
I think you don't even need to go that far to make the argument you want to make about what the paper does.
Fair enough, Your Honor, but it is also true that the servicing agreement that BC 57 never saw contains at least 4 provisions that say that the servicer is not authorized to release the mortgage without written instruction. And so we have to find the written instruction somewhere. The documents of the loan package have to be read together under Illinois law. And so reading them all together, the best reading, as Judge Shaw concluded, is not that the authorization document provides the written instructions, but rather that the written instructions have to come from someplace outside of the loan package, because otherwise the protections in the servicing agreement would have had no meaning and would have been of no effect. The individual investors who made these loans relying on the fact that they were going to have first position mortgage liens would have relied on that fact and eliminated it at the same time. And that doesn't make any sense. It is a much better reading of the entire loan package to give meaning to the 4 provisions in the servicing agreement that require written authorization than it is to give meaning to the 3 lines on a single page that is doing multiple things. And we should also remember this was a fraud, and BC 57 was the second lender here. So BC 57 knew the individual investors existed, knew they had a first position mortgage lien, and it is BC 57 that failed to do adequate due diligence to determine whether Equitybuild Finance could actually release that mortgage. What we actually see in the record is not a Scribner's error, not mutual mistake. What we see in the record is that Equitybuild Finance and Equitybuild Inc. would tell BC 57 whatever BC 57 needed to hear to get a loan. And it is on BC 57 that it failed to do the due diligence that would have allowed it to say, wait a second, you can't have the borrower release the mortgage. It has to be the lenders who release the mortgage. And you can't say that you have the authority to do that if you haven't provided the actual written instructions that the servicing agreement that you say gives you that authority requires. And for these reasons, we believe that you should affirm the holding of Judge Shaw in the district court.
Thank you, Mr. Stein. Mr. Augenlicht.
May it please the court, my name is Robert Augenlicht. I'm an attorney representing 1839 Fund 1, which is one of the individual investors. I'm here to address the second portion of our response brief, which argues that the court below correctly ruled that the Illinois Mortgage Act replaces a common law rule that payment alone operates to automatically extinguish a mortgage.
Do you agree, before you get into the substance of that, that that is a question of law that we should review de novo?
Yes, Your Honor. That would be a question of law. I'd be hard-pressed to say.
I know this is a proceeding in equity, but that seems like a clear
This
question
specific
of law.
issue, Your Honor, is unquestionably a question of law. I think it's important to note here that BC 57 brings this as an alternate argument in which they're attempting to assert that even if they do not have bona fide purchaser for value status, that the payment alone to some agent of the mortgagee is sufficient. The Illinois law does not support this contention. I would also note that even the cases that BC 57 relies on, none of them, in all of those cases, the subsequent lender was found to be a bona fide purchaser for value. So even on its own terms, it fails. But more to the point, Illinois law does not recognize this principle that that payment by itself operates to extinguish a lien.
You agree, though, that Section 2 doesn't discuss how to release a mortgage lien. It discusses how to release a mortgage lien. It doesn't discuss how to extinguish a mortgage lien or what it means for a mortgage lien to be extinguished. So you don't have a plain language. How can you say that the plain language of the statute addresses this?
Well, Your Honor, this concept that there is a distinction between these two things finds no support. Appley provides no support for the idea that there is a distinct concept in Illinois law between the releasing of a mortgage and the extinguishment of a mortgage. The Illinois Mortgage Act, the argument here is that the act entitled the Illinois Mortgage Act somehow doesn't regulate how mortgages operate. And that simply makes no sense.
What about the fact that it doesn't specifically abrogate the common law?
Your Honor, so it does not specifically state that it's there to abrogate the common law, but one of the tests that we see in Illinois common law for whether a statute operates to abrogate the common law is whether or not there is an irreconcilable repugnancy. Here, the statute contains mandatory language, shall be released, and superseding language, only in the manner provided herein. That is simply incompatible with, only in the manner provided herein is simply incompatible with, in addition to other methods recognized by common law. I would also point out that this concept that if you look at further statutes, this concept that a lien is extinguished by payment isn't supported. So the Illinois Mortgage Act references the Illinois Certificate of Title Act, which provides an alternate route for releasing a mortgage. That act says that if a title company has received a payoff letter and has then paid the funds per the direction of that letter, it is authorized to itself release a mortgage. But it places an important caveat on that. It says that the title company cannot do that if it knows that the lender objects. If the lien is extinguished, then the lender's objection would be meaningless. What power could the lender possibly have to object if, upon having the payment that was requested made, what power could they have to object to it if it works the way that BC 57 says? I would point to two cases that we have in our brief, in addition to the Creepers case, which the court asked counsel about earlier, the North Shore Bank v. Sheffield Wellington case, and the Ames Capital Corp versus Interstate Bank case. I think the important thing to take from both of those cases, in addition to the fact that the North Shore Bank case specifically says that other methods of releasing a mortgage or that payment alone is not enough, is that in both of those cases, even after full payment was actually made to the lenders, which the court found did not happen in our case, but even after full payment was actually made, the lien continued to do something. In the North Shore Bank case, the unreleased mortgage continued to allow the bank to participate in the litigation. That's a significant legal right. In the Ames case, the unreleased mortgage allowed a new lender to be subrogated to their position over lenders who recorded their mortgage as senior to them, which means that a mortgage that has, and the court was careful to note that the result would be different if the release had already been filed prior to the new lender coming in and recording their mortgage. Thus, we have three different instances, both the Illinois Title Act and these two cases, and the Creepers case, which is also a subrogation case, wherein mortgages keep doing something even though full payment was actually made, which again didn't even happen in our case. The North Shore Bank case is even stronger in that in that a release was actually issued, yet not recorded. And that was the court's point, was that simply the release itself isn't even enough, there must be delivery of the release. I would just like to go with a little bit of remaining time I have left and address some of the sort of doom and gloom arguments that are presented, namely this idea that if this rule is somehow, that if the plain language of the statute is upheld, that the mortgage industry would collapse. All of these issues of how a mortgage is released and what takes effect and who has what burden to do are policy considerations. Here, the legislature has said that the policy consideration favors burdening new lenders to make sure that the person releasing their mortgage actually has authority to do so. I request that the court affirm the decision of the court below. Thank you, Your Honors.
Mr. Rockleys.
Good morning. May it please the court, counsel. Michael Rackless. I'm one of the attorneys that represents the receiver in this action. I wanted to just follow up on a couple of points that Judge St. Eve in your questioning has raised in regards to the work of the district court, the role of district court, and the role of this court in this setting which involves an appeal of a distribution plan. As the court's question makes correctly clear, the district court has wide discretion in its role and exercise that discretion properly in its determination of what is, in this context, really a fact question in regards to the agency issue, which is really and another point here, which the court properly noted, is the role of this court in a review of those issues. The court correctly notes that this is not a reweighing of what the district court had done. Both the wide discretion of the district court, the role of this court has been repeatedly raised in cases that this court has issued, whether it be wealth management, whether it be enterprise trust, where Judge Easterbrook wrote that opinion, and other cases.
It doesn't matter who writes the opinions of the court.
No.
They speak for the court.
Absolutely, Your Honor. A few comments also on some of that evidence on agency that has been raised. As noted, agency is a question of fact, and so it is correct that the receiver did submit an avoidance disclosure, but that is not a way of suggesting that there's not a burden that was on the litigants themselves who were dealing with the priority question in order to raise those issues and meet a specific burden, which Judge St. Eve had discussed in your questioning before in regards to that issue. BC 57 did not, its facts, as the district court found, did not meet its burden of proof on that issue. I note one note in particular, just as an example of the evidence before the court in reaching its conclusion, involved what is cited to now as the mortgage. There are mortgages that are on file. They claim that there is express actual authority given to EBF or Equitybuild Finance by reference to C/O. And so on the face of the mortgage, it lists out dozens of investors, C/O, Equitybuild Finance. Their claim is that that provides the actual authority that they are now relying upon, in part. If you look at that, if you look back at the mortgages, they do not express any reference to actual authority to release a mortgage without the investor lender's consent. Importantly, compare that to the other documents that they had in their possession. For example, the releases, which provide no such authority, which provide different names in terms of Equitybuild Finance, no C/O. There's clearly, when you look at the totality of the evidence presented to the court, none of which, by the way, the process is not being appealed. These summary proceedings that the court had initiated, the claims process, the sales process, none of those are on appeal. Other than this very narrow issue, it's clear that the district court properly exercised its review. It should be affirmed.
The case is taken under advisement, and the court will take a brief recess before calling the fourth case. Our next case for argument is Brown against Cash. Mr. Camarena.
Your Honors, opposing counsel, may it please the court, my name is Baul Camarena and I am the appellant's counsel in this case. This is a consumer protection case and it presents an issue about how the Fair Debt Collection Practices Act interplays with the case and controversy requirement of Article 3 of the United States Constitution. This case presents a fairly simple question, and I would phrase that question in this way. When plaintiffs present evidence that they are self-employed and that they were caused to interrupt their self-employment because of a defendant's illegal conduct, have the plaintiffs presented evidence that they have an injury that will grant them standing pursuant to the case and controversy requirement of Article 3? Case laws that have addressed this issue have all answered yes, that they have presented.
What does the record show about what Brown's self-employment was?
It has her affidavit, Your Honor, doesn't state the type of self-employment that she had.
What does the record show about how the income changed as a result of this act?
It doesn't have any information on that, Your Honor.
The district court invited your client to provide that kind of information, and your client chose not to. What would the consequence of that be?
Well, Your Honor, the district court asked the plaintiff in this case to provide information with respect to standing. The district court didn't specify anything with respect to her employment. Other cases that have looked at this exact same issue have held that it's a reasonable inference to make.
Any court of appeals?
No, Your Honor.
No, not this court, not any court of appeals.
As far as I know, Your Honor, no court of appeals. No. But there's been at least three district courts in Northern District of Illinois who have held under the exact same circumstances.
Why not put in the evidence when the district court specifically asks for it? You knew standing was at issue, and the district court, correctly so, invited you to supplement the record and address why you have standing. And your response was essentially, no, I'm not going to give you anything else other than this affidavit.
Well, Your Honor, when this issue had been raised by the district court, there had already been several cases that had dealt with this. And those three cases have all said that
but there were also if you're referring to the district court cases, there are multiple cases up here, and after TransUnion, making it very clear that just a violation of the statute isn't enough, that you need to show some concrete injury.
That's absolutely right, Your Honor, and that's exactly what the appellee points out. And
what is the injury here?
The injury is time was taken away from their self-employment.
And what's the harm?
The harm is, as Judge Connelly pointed out in Brown versus Weisenberg, it is a reasonable inference to make that when someone is self-employed and they have to take time away from their self-employment to deal with an illegal conduct.
But in that case, I believe we knew what the self-employment was.
Well, I must say I don't understand why it's a reasonable inference. Suppose the plaintiff is self-employed as a writer of novels, right? She might show that it took longer to write the next novel and postponed her next payment. I mean, that would be something one might be able to show. But having chosen not to show anything, very difficult to see how it's different from deciding to spend a half an hour watching a TV show.
I understand, Your Honor, and it's certainly possible that the true fact can look at this circumstance and say that there hasn't been, they don't believe that the plaintiff would have lost money, would have been out money, but
I gave you the example for a reason. There are famous novelists who, for their whole careers, worked every morning tirelessly, right, turning out 40 pages a day, and then in the afternoon they had plenty of free time. So if there was an interruption in the morning time, it might be serious. Interruption in the afternoon would not be serious. You could figure that out with an affidavit or some other explanation, but with nothing.
Your Honor, I would give the example of how lawyers typically operate. We're used to working with the billable hour, and I recognize that if I spend 6 minutes...
Is Brown a lawyer?
No, Your Honor, but
Does she work by the billable hour?
There isn't any evidence.
There's no evidence.
There isn't evidence, but whether she's an Uber driver or a lawyer, the principle stands in that if I spend 6 minutes taking care of my children, or 6 minutes watching the television show, or 6 minutes dealing with a false statement by a debt collector, that's 6 minutes that I can't spend billing a client or driving a ride if I were an Uber driver. So it's a reasonable...
Which is why if you had submitted evidence that she was an Uber driver or billed her clients, we might be in a different position.
Yes, Your Honor. The three other courts that had
It would be really interesting if you submitted evidence that she was an Uber driver who missed a call as a result of this.
Yes.
But of course, there's nothing.
Well, Your Honor, the three courts that have already addressed this issue...
District courts' decisions are worth nothing on appeal. We have to follow the decisions of the Supreme Court of the United States, and we're sometimes influenced by the decisions of other courts of appeals.
Yes, Your Honor, absolutely. The district court's decisions are not binding on this court, but they may be persuasive. And the three courts that have dealt with this, and no other courts, as far as I can tell, has addressed this issue, and the defendant hasn't pointed out any other courts that have addressed this issue. But every court that has addressed this issue has said that a claim of self-employment coupled with a claim that self-employment had been interrupted it can lead to a reasonable inference that the plaintiff had lost money because of the defendant's illegal conduct. Court doesn't have any questions. I will reserve my time for rebuttal.
Certainly, counsel. Mr. Foster.
Good morning, Your Honors. May it please the court. My name is Nabil Foster. I'm here representing CACH. This case really deals with a gap in the record, and a gap in the record that becomes significant regarding the increasing burden of proof that a party has. A party who invokes the jurisdiction of the federal court has the burden to meet the Article III standing, and that's what in the Julian versus Defenders of Wildlife, I think I'm pronouncing it correctly. I think it's Lujan, excuse me. I think I may be partially dyslexic, apologies. And that case, the quote that I remember from it is that the burden of the plaintiff increases with the stage of the litigation. So I think the quote is, with the manner and degree of evidence required at the successive stages of the litigation. I think a lot of the cases that my opponent has cited deal with motions to dismiss. And we know the standard on 12b-6 is the taking allegations.
This is actually a 12b-1 problem.
Excuse me, 12b-1, right, correct, Your Honor. 12b-1.
And in 12b-1, the district court can make findings of fact. It's not bound by the allegations of the complaint.
Yes, Your Honor. And in this case, we are at the stage of summary judgment, which is famously, a famous quote is that is the put up or shut up moment in a case. And in this particular case, there was nothing to support the allegation of the value of the lost time. Certainly, there have been district courts that have found that lost time could be, Your Honor, as you pointed out, an author who writes at a particular time of the day, but then takes that time off. Who's to say that particular time was actually resulted in an actual concrete injury? In this case, there's nothing to support the allegation of the lost time. I don't think I have a great deal more other than say that I think Judge Dow and Judge Gettleman they've taken the instructions from this court to heart, and they are the ones who spotted this issue early on and required the additional supplemental briefing. And Judge Gettleman's opinion, I think, is spot on. So unless the court has any particular questions, I would say that the district court's opinion should be affirmed.
Thank you, Mr. Foster. Anything further, Mr. Camarena?
Your Honor, if I may for a moment, I would point out that Judge Gettleman stated that there was no evidence in the record to support her claim that she had lost money. I would have to take issue with that because while there can certainly be an argument that there was inconsistent evidence with respect to this, it can't be said that there was no evidence because she did submit her affidavit stating that she's self-employed, that she interrupted her self-employment, and had the defendant not made a false statement, she would have simply tossed that letter into the garbage. So I'd ask the court to consider that. And if the court doesn't have any other questions, I will rest.
Thank you, counsel. The case is taken under advisement.
Thank you, Your Honor.
Case number 5 for argument today is United States against Brasher. Ms. Christensen.
Good morning, Your Honors. May it please the court. My name is Joanna Christensen, and I represent the appellant, Brunel Brasher. The district court plainly erred by including as relevant conduct 2018 and 2020 transactions when calculating the amount of drugs involved in this case. Of course, the government argues that Mr. Brasher has waived this issue instead of forfeited. Mr. Brasher does not agree. Waiver is intentional, and there's no indication in this record that the failure to raise the issue in the district court was intentional. In fact, it was most likely negligent by defense counsel because the issue is fairly plain from the record as it is here. The key is strategy, whether the defense counsel strategically decided not to raise this issue, and the government points to potential—
Ms. Christensen, before you move beyond waiver,
Sure.
If we agree there's no waiver, would we have to overrule any of our prior cases, like the Hernandez case, where we have said if a PSR is filed and the pre-sentence investigation report lays out what the guideline calculations are and a defendant objects to some of them but not all of them, that you can draw a waiver from that?
I don't think you would have to overrule that. I think there are several cases. The Jaime case is probably the primary one where actually that defendant agreed in his plea agreement that an enhancement would apply, and the court still found that that was not intentional waiver. And I think that there's still room for that negligence argument, even with some of the case law about pre-sentence reports and adoption of pre-sentence reports. In this case particularly, the pre-sentence report doesn't connect the relevant conduct in the way that the guidelines envision that it should. The pre-sentence report writer did not talk about how they were related, their temporal proximity, their regularity, their similarity.
I have a problem with why that should matter. I mean, the norm in litigation, even in criminal litigation, is that district judges have to address the issues that the parties contest. So suppose this is just forfeiture. What's wrong with the district court saying the defense hasn't made anything of this relevant conduct issue, so here we go? Right? Judges, actually the Supreme Court said in Shinanang Smith that judges should not and sometimes must not inject issues into a case when the parties don't want them. Your argument to the contrary is that district judges must make particular decisions even when not asked. Why do they have to do that?
I'm not sure that's my argument exactly, and I think—
Well, the judge wasn't asked to decide on relevant conduct.
Correct.
The pre-sentence report makes a recommendation, and the judge just passes it through because nobody asked the judge to look at the issue.
Right.
So the question I'm asking is, why must a judge raise on his own an issue that nobody presented for decision?
Well, I have two answers to that. One is there's a reason plain error review exists in this court and not in the district court, and it's for situations like that. And secondly, when there is an error that's clear from the record,
No, you're not getting my question. My question is, why is it error at all for a judge to confine his attention to the issues raised by the lawyers, given the holding of the Supreme Court in Shinanang Smith?
It's not necessarily error of the failure to address. The error is the calculation of the relevant conduct. That's clear from the record. So the judge certainly, no judge has to sua sponte raise issues on behalf of either party. But when there is an error in the calculation of the guidelines, the criminal rules of criminal procedure allow a defendant to raise that under plain error in the Court of Appeals. And we're not necessarily saying the district court judge has to make arguments on behalf of the defendant or point issues out on behalf of the defendant. But when there's an obvious issue in the district court, we can raise that on appeal. And in this case, it is an obvious issue where you have three separate instances of conduct that are all put together that have such an effect on a defendant's base offense level.
Is there anything the district court could have done to prevent an error here? Is there anything, because the district court asked at the end very specifically a question about the guidelines.
Correct.
It wasn't just a throwaway, is there anything else, but it was pretty specific. Is there any question like that a district court could ask at the end where there would be waiver from your view?
Well, as far as waiver, I think that the court might have to ask the specific question. We realize, of course, that that's just not what the way sentencing hearings work.
Yeah, you could be in there forever.
Right, exactly. And, and that's where it falls back on defense counsel and the potential negligence of a failure to raise the issue by defense counsel, is that that's the interplay between the two. The judge did what the judge could have in this case. The problem is a step back with defense counsel's failure to raise the issue, which has been recognized as a reason that it would be plain error review, and certainly, rather than waiver. We're certainly not arguing the full review that otherwise would be applicable here.
Ms. Christensen, how do you get around the plain error here in light of our case law? We have a lot of case law that talks about relevant conduct being appropriate where you have similarity and regularity between the conduct. And the government has identified here lots of similarity. There may be some differences as well. And if this were de novo review, maybe it would be different. But how do you get around the plain part of plain error, given the similarity and regularity with Brasher selling to Crontes at regular intervals?
Sure. The Cronce's conduct was not the offense of conviction, so that has to be under relevant conduct. And whether it's similar to the offense of conviction, not to anything else, but the offense of conviction. And the government admits that it's not temporally proximate, so we don't really have that, and they don't really make an argument about regularity. So it's similarity, and the similarity really is that it was Mr. Brasher involved in drug transactions, and this court has held.
Well, it was more than that. They all involved meth. The drugs all started from California. The drugs all ended up in southern Illinois. Almost all of it, the transactions involved pound quantities. So there are multiple things. Again, if this were de novo review, it might be different. But given our case law, given those similarities, how would any error here be plain?
I think the similarities are similarities in every case. Every case that ends up in the Southern District of Illinois is going to have similar facts. Is going to have a person who's supplying, Mr. Brasher, large quantities. Most distribution chains at some point have large quantities. Methamphetamine is a particular problem, I think, in the Southern District of Illinois. We see quite a few cases involving meth from that district. And methamphetamine, as I say in my reply brief, originates 85% of the time in California from Mexico. So these are very broad similarities between this case and every other case. So the real key component is Mr. Brasher himself. That's the argument about similarities. It's just, there can't be just the connection to Mr. Brasher. And it's the clear tail wagging the dog situation that we have here. So I see that I am into my rebuttal. Unless the court has further questions, I'll reserve the remainder of my time.
I hope the dog had a heated doghouse.
Well, mine do.
Were you here for our first case?
I was here for the first case. It was a little hard to listen to, actually. Very sad.
Mr. Bloodworth.
Thank you, Your Honors. May it please the court and counsel, and I can assure the court that we will not engage in a discussion of choke collars in this, but what I would like to discuss is that Mr. Brasher, in the government's assessment, has clearly waived this argument. It's clear from the record in this case that Mr.
What shows
Brasher-
the intentional nature of it?
Right, Your Honor, because waiver is intentional, and the best piece of evidence or reflection from this record that shows that it was an intentional waiver is what Mr. Brasher objected to the PSR. He objected to how the methamphetamine would be calculated, but not how much methamphetamine should be attributed to as relevant conduct. His objection to the PSR was that the meth actual should be counted on a policy disagreement as mixture of substance.
We have said in some recent case law that there's no longer a bright line rule about this, and that the bright line rule that every objection not raised at sentencing is waived is essentially of the past. So
Right.
how do you distinguish this case from our case law?
If I understand the court's question correctly, it's through what transpired in this sentencing hearing. Mr. Brasher's specific objections, not only to the methamphetamine, but to his probationary status. His objection was that he believed he was not on probation, his objection was not when his relevant conduct began, which would include or bring in at that time the 2-point enhancement, was that he just believed he wasn't. You follow that up with the colloquy between the court and counsel. The district court in this case clearly asked if he was understanding Mr. Brasher's objections correctly, to which Mr. Brasher's counsel reiterated that he was, and that his objections were only to how the
There's a
methamphetamine
reason
was
we're
kept.
stepping away from this bright line, because all of these examples show just as much neglect, some arguable incompetence, as they might an intentional waiver. So maybe it would be helpful, after you finish answering Judge St. Eve's question, to move to the merits.
Certainly, and just one more point to Judge St. Eve's question is, following that colloquy between the district court and Mr. Brasher's counsel, Mr. Brasher himself acknowledged that he was part of a criminal enterprise, particularly with the Cronces. And Mr. Brasher himself, who is no stranger to the federal system, we can see that from or no stranger to the criminal justice system, we can see that from his criminal history, conceded in his allocution statement that this conduct
But
from
the
the
question
Cronces
before
was
us is
relevant.
not whether or not Mr. Brasher committed this relevant conduct, but whether the conduct was relevant and sufficiently related
Right.
to the conviction here.
I don't disagree with you, Your Honor, but I think through all of that, it shows that there was a concession and a calculated decision to proceed in the manner in which they did, and the objections that they raised. And then just very briefly to the point on waiver, there was sound strategic reason to do so, because Mr. Brasher wanted to convince the court that he was truly accepting responsibility.
Couldn't you make
and
that
contrition.
argument in every case, though? That seems, if intentional waiver comes about because you want to make sure you're getting the third point, it seems like the government could argue that in every case.
It's hard to speak hypothetically, Your Honor, because criminal cases, as we all know,
Intentional waiver seems like it has to be something more than that. Otherwise, it would get swallowed up in every case.
And I understand that there's the potential for that.
To see that, just think about what would have happened if Judge Gilbert had said to defense counsel, so, do you accept everything in the pre-sentence report except what you're now arguing today? If defense counsel had said yes, that's a waiver. But of course, that question and answer never happened. That's why this is fuzzy. Maybe we should resharpen the line and say, unless that happens, it's a forfeiture rather than a waiver.
I certainly understand Your Honor's point. I would agree that question wasn't asked in that specific direct manner. But it was asked after the district court
specifically delineated the amounts involved, the district court asked if there was any objection to those amounts. And affirmatively, the defense said
It just means there wasn't an objection.
Right, which I think would signal a clear intention or relinquishment of that known right. But be that as it may.
On the subject of amounts, is it your position that district court has no obligation to explain how these amounts come to be folded in as relevant conduct?
No, I wouldn't say that the district court does not have the.
What's the source of that obligation?
I'm sorry, Your Honor, I don't.
You would not say they have no obligation.
Well, correct.
Okay. Because they have some obligation.
Yeah, I think the body of case law in 3553A and all of that requires the district court to explain it.
And so that's independent of whether a defendant raises that.
Yes, but the level in which the court has to specify, its relevant conduct calculations or its reasons for its sentence depends on a variety of factors, most of which are not present here because there was no objection. There was no affirmative statement that they needed clarification on how the court was.
What level do you see here where the district court did do what it was obligated to do?
I see that the district court listened to objections, ruled on objections, decided those objections, asked if there were any more, and the defense
No,
court
I'm talking
said
about
no.
on the issue of relevant conduct.
The district court was faced with uncontroverted facts from the PSR, reiterated those facts in terms of quantity calculations, and then asked if there was any specific objection to those quantity calculations, to which there was none. I think that's what the district court's required to do, and the district court did so here.
I thought you just told me that you understand the district court to have some obligation to connect some dots with relevant conduct.
I think depending on how it's raised, and it wasn't raised at all in this specific case. I think there are a lot of variables that could impact how much a district court explains its sentence, or how much a district court explains its relevant conduct calculations. But in this case, there just was no
Is your
objection
argument
whatsoever.
that because there was no objection, that just relying on the PSR and incorporating it
No.
satisfies that obligation?
No, I think that's a variable to consider in how a district court explains, and I addressed this in the government's brief. If you give me just a few seconds. I apologize, Your Honor. I can't find where that was in the government's brief. I know that it was mentioned. But my point is that's a variable. That's certainly something that should go into how a district court explains its sentence. But waiver aside, the opposing counsels conceded that at a minimum this is forfeiture. And to get to Your Honor's question earlier, we're engaging in a lot of factual discussion, a lot of factual dispute, for lack of a better word. But what's clear is we're engaging in a debate. This court has held that debatable facts in those scenarios doesn't amount to plain error. It's not plain on the record that any error occurred. The government certainly submits for a lot of the points that Judge St. Eve made that there was no error, plain or otherwise. But it's the defendant's burden on plain error review to demonstrate that there is. And engaging in this debate about what facts are important in determining temporal proximity or course of conduct illustrates that any error, if any error occurred, which the government submits did not, is not plain. And therefore the defendant fails on that plain, or Mr. Brasher fails on that plain error analysis. It's an incredibly deferential standard for a reason, and I think it illustrates what Your Honors ask about those factual disputes and those factual colloquies and debate, for lack of a better word. So unless the court has any other questions, the government would rest on its brief on the remaining points and ask the court to affirm the sentence below.
Mm-hmm. Thank you, counsel.
Thank you.
Anything further, Ms. Christensen?
Thank you, Your Honor. I think what I perhaps didn't say very well about the distinguishing between what the district court has to do is the difference between making factual findings and legal findings. And we are not challenging the facts. I know that this is a fact-heavy analysis, but I'm not disputing any of the facts that are in the record. They're in the record, Mr. Brasher admitted them. It's whether the court has a duty to make legal findings about the guidelines, which it must consider and correctly calculate, when the facts are not enough to support those legal findings. And the court may adopt the pre-sentence report, but if the pre-sentence report doesn't make adequate findings or adequate connections, then that legal issue may be reversed on plain error. And we've seen cases like that regarding the guidelines. Jaime and the Hyatt case that are cited in our briefs are both cases where the facts were essentially not disputed in the record. It was whether the court had made the correct legal finding about the guidelines. So in my few seconds left, I would like to talk about counsel's objection to the guidelines, which was based on the Cornell case and the type of methamphetamine, which did border on nearly frivolous because there were lab reports regarding the purity of the meth. And in that case, it does look like negligence rather than an intentional decision to waive it. Unless the court has questions, I'd ask to reverse and remand for resentencing. Thank you.
Thank you very much. The case is taken under advisement. Our final case of the day is Wolven against O'Malley. Ms. Marcus.
Good morning. May it please the court, Meredith Marcus on behalf of the appellant, Edward Wolven. Social Security Rule SSR 16-3 contains a two-step process for evaluating subjective symptoms. Judge Malloy in this case never should have moved on to the second prong of that analysis because first, step one was satisfied under the substantial evidence burden. At the first step, the consideration is whether the claimant has a medically determinable impairment that should reasonably be expected to produce the symptoms alleged. And the judge is to look at signs or laboratory findings such as MRI results. Under the language of SSR 16-3P, one is not to consider the severity of symptoms, and the ruling also goes on to state we will not evaluate an individual's symptoms based solely on objective medical evidence unless that objective medical evidence supports a finding that the individual is disabled. In other words, the intensity and persistence in this case never needed to be considered because in terms of the objective evidence, it was satisfied. And we know this because no less than 5 specialists in this case said so. Dr. Lorber at the hearing stated that the MRI showed a significant pathology that could not be ignored. Dr. Julian Freeman authored a report, and in that report, he wrote that the MRI imaging not only provided the diagnosis, but also the explanation for the severity of symptoms despite the fact that there was normal clinical findings. Dr. Hagendorn, Wolven's treater, twice authored opinion reports, and in terms of the objective evidence, pointed to the MRI as rationale for those limitations. Drs. Carter and Keene earlier in the records pointed to the disc degeneration and stated that that could be a source of the pain. And then Wolven was also sent for a discogram, which is used to evaluate back pain, and it reproduced back pain at all of the levels in which he had disc herniation. So not only did Judge Malloy violate this first step, but then he moved on to the second prong of SSR 16-3P and created an even higher burden for Wolven to meet of this entirely consistent requirement in terms of intensity and persistence that's nowhere listed in Social Security Rules SSR 16-3P or 20 CFR 404-1529C. The judge then evaluated only 4 rationale in terms of rejecting Wolven's symptoms. The first was pointing to the normal clinical findings. However, earlier in the decision at the record at 1698, Judge Malloy points to a whole wide range of abnormal findings, never building that bridge between why the normal findings in this case should outweigh the abnormal ones. Further, as just stated, Dr. Lorber and Dr. Freeman both explained that the MRI findings in this case explain the fact that at times there were normal clinical findings. And Dr. Lorber, in the hearing, was asked about these normal clinical findings, and he provides an explanation. He explains that listing 1.15 at step 3 of the process cannot be satisfied because Wolven didn't consistently have the abnormal findings throughout the record, but he had enough abnormal findings along with the severity of the MRI findings to support that Wolven could not work. This leaves daily activities, which in this case, the judge pointed broadly to Exhibit 11E and 13E, and pointed to minimal daily activities without any consideration for the fact that those activities were done with Wolven needing to sit, stand, walk, most importantly, take breaks and lie down. This court has held that without some attempt by the judge to explore the supposed contradictions here, they do not provide a sound basis for concluding that Wolven's report was inaccurate. The third rationale that the judge used, that the treatment here was not entirely consistent with that of a totally disabled individual. But again, at the record at 1698, the judge goes through physical therapy, occupational therapy, aqua therapy, injection therapy, home exercises, TENS unit, opiate pain medication, narcotic pain medication, that he was not a surgical candidate, and that even with all of these heavy pain medications, he was still experiencing breakthrough pain. So it leaves the question of what in this case is lacking that Wolven does not have the treatment that would be required of a totally disabled individual. The only other rationale that the judge points to is that Wolven is in no acute distress throughout the record, and that he is agile in times getting up and down from the floor. But again, Dr. Lorber in the hearing was confronted with all of this evidence and specifically stated that it would not alter his opinion. And notably, no one in this case is claiming that Wolven cannot get up and down from the floor. What's clear is that throughout this record, throughout an 8-year span, Wolven was lying down in medical appointments and at home to alleviate back pain, in addition to all the other treatments that the doctors had offered.
But the ALJ, in the opinion, addressed this evidence and noted, for example, the laying down, that there was contradictory evidence, that when somebody came in the room, he was able to get up quickly, jumped right up, inconsistent with somebody who would be in such pain. It sounds to me like you were asking us to reweigh what the ALJ did.
I'm not asking for a reweighing of what the ALJ did. I think what the judge did is essentially play doctor and put his opinion as to.
But in making these determinations, the ALJ looked at the medical records, looked at the consulting physicians, and didn't just say, oh, I'm taking this person's opinion over this doctor's opinion. The ALJ said, I am not giving as much weight to this doctor's because here's all this contradictory evidence in the record.
So Dr. Lorber addresses this at the hearing and states that it could be a method utilized to alleviate back pain. So he is confronted with the fact that Wolven was lying down. But again, in all the records that he is observed to be lying down and coming up in an agile nature, they're not questioning whether he's malingering, whether he's doing that to showboat. They're prescribing even heavier narcotics.
They don't need to question that in order for the ALJ to read the assessment and decide to give it less weight given the facts that are clearly set forth in the medical records. It sounds like you're saying, oh, because these are the treating physicians, and there are several of them, that the ALJ erred by not accepting their medical opinions.
So it's not the treating physicians. It's Dr. Horgendorn would be the only one. Dr. Freeman was hired by Wolven to review the record and reviewed the evidence of him getting up and getting down. But Dr. Lorber is an independent medical expert who was called by the agency to review this record and still didn't find the fact that he was getting up and down.
It sounds like you're arguing that the ALJ has to accept these opinions without looking at other medical evidence in the record, which the ALJ did a pretty thorough job of reviewing.
So the judge might have done a thorough job of laying out the evidence on one hand and the other, but never in explaining and building that bridge why one outweighed the other. Particularly the fact that the doctor was confronted with this evidence. But even if we don't credit the fact that Wolven needs to lie down, which clearly Dr. Lorber didn't, I mean, his testimony says that he might not need to lie down, he still found that he couldn't perform a full range of sedentary work. And Dr. Freeman still found that he couldn't perform a full range of sedentary work. So even if the need to lie down is not supported in this record, although I would argue with that because his own pain management doctor, Dr. Hagendorn, makes reference to the fact that he's more comfortable in this appointment, but there's times where he's in disabling pain or back spasms and can't get up off the ground. That this rationale on its own shouldn't be a reason to reject multiple different treating providers who found still that he couldn't work, maybe that he didn't need to lie down.
You know, it's a tough dance because we do have this requirement that a logical bridge be built. But we've also said where an ALJ thoroughly and, in detail describes all the medical evidence, that's enough to support the ALJ's ultimate conclusions about, the weight it's affording to some evidence versus the other. So, how we have these two strains we have to be faithful to. So how does that help us see things the way you want us to see them?
I think because in this case, and the judge never mentions it in his decision, he focuses heavily on these normal clinical findings, which you have two doctors.
But he mentions all the abnormal findings too. You say he focuses on the normal, but that's after he's laid out everything, which includes the abnormal findings.
Right. But he never mentions, and particularly I would say with evaluating Dr. Freeman, which he rejects purely based on the basis of the normal clinical findings, that this doctor, who's a neurologist, so another specialist, explains that in his report and says that the MRI findings on their own explain that not only the diagnosis but the severity of symptoms despite the normal clinical findings. And never in this decision does the judge explain then why these normal clinical findings outweigh the abnormal ones, where you have doctors specifically stating this is enough because this shows how severe the symptoms are.
Mm-hmm. Thank you, Ms. Marcus. Mr. Neltner.
May it please the court, my name is Andrew Neltner and I represent the Commissioner of the Social Security Administration. This case really does just come down to how the ALJ weighed the evidence. There's this bucket of evidence that the ALJ found particularly persuasive. The ALJ talks about the normal clinical findings. The ALJ talks about the ease with which Wolven got up from off the floor. The ALJ talks about the lack of acute distress despite the severe claims of pain. That evidence is at the core of this decision, and it is what the ALJ goes back to time and time again to question some of the more serious findings in the records or some of the more serious opinions in the record.
How do you respond to Mr. Wolven's argument that the ALJ failed to address the evidence that Mr. Wolven didn't respond well to medication?
I think that you can, first off, I would say that the ALJ did not specifically winnow down and say, okay, this is how I'm going to address that piece of evidence. But I think it's clear when you read the decision as a whole, the ALJ thought that Wolven had some very severe functional restrictions. The ALJ didn't sort of give short shrift to this type of evidence that Wolven was not responding to treatment. In fact, he found that Wolven was restricted to sedentary work. If the ALJ had thrown all of this stuff out, he would have found that Wolven was much more capable than he did. And I think that's clear evidence that the ALJ was considering the weight of all of the evidence that was presented to him.
The medical evidence found that Wolven would have a problem with frequent lifting, frequency. And so where do you see the ALJ addressing how the sedentary work limitation accommodates, sedentary work finding accommodates a frequency of lifting problem that Wolven has, as opposed to sedentary work by definition involves lifting no more than 10 pounds. Well, that's weight, that's not frequency. So where did the ALJ address that particular limitation?
I don't think that the ALJ addressed that specific restriction, but I also think that, or I'm positive, that the ALJ never said that he was adopting that restriction. There were a couple of doctors that did talk about a need to limit the frequency of lifting, but the ALJ concluded that the restriction to sedentary work with the lower weight limitation was adequate to address what he thought were Wolven's restrictions. So pointedly, the ALJ did not specifically address the frequency issue, but the ALJ clearly was aware of all this evidence and the myriad opinions that were not quite all over the map, but that had different levels of functionality found by the different doctors throughout the record. So the ALJ had to take all this evidence and sort of reach a conclusion as to, okay, what do I think Wolven is actually capable of? And I think that there's this more than sufficient evidence cited by the ALJ in the record throughout that supports that finding. Again, there were 17 instances where Wolven was found to be not in distress. 8 instances in the record where he had normal gait. There were 14 instances with a negative straight leg test. 12 times he could walk on heels and toes and do deep knee bends. 15 times where he had normal strength, sensation, balance. And then there are the 4 instances where he got up off of the floor and the doctors made specific notes of his ability to do so. This is substantial evidence in support of the ALJ's residual functional capacity assessment. This court has looked at this specific type of evidence in other cases, specifically in Baki and Prill, both v. Kijikazi, which are cited by the commissioner in his brief, that this court saw ALJs relying on this type of evidence in cases where there were back impairments and found that evidence, or cited that evidence with approval in terms of the ALJ supporting his or her decision in those cases.
Let me ask you about another functional issue, the twisting and bending. I mean, are we clear on this record whether the ALJ adopted that limitation or not? Where do you see that adopted that limitation in the context of the sedentary work finding?
Right. So in terms of the twisting and bending, the ALJ mentioned multiple times, I believe 3 times, that the restriction to sedentary work would accommodate any postural restrictions that the ALJ found that Wolven had. And then if you go and look
is that how you read this? The ALJ says postural limitations do not typically erode the occupational base for sedentary, unskilled work?
That is how I read it, Your Honor. That regulation is saying if you have postural limitations and you are restricted to sedentary work, you don't really have to address the postural limitations because it's addressed inside the restriction to sedentary work. So if someone has postural limitations and they're restricted to sedentary work, you don't really need to worry about the postural limitations because it's already addressed.
Isn't that odd for a person like Wolven who had problems both sitting and standing for prolonged periods of time? How can one say you don't have to worry about postural limitations if you're sitting down when he has problems sitting down for too long? Do you see what I'm saying?
I see what you're saying, but I don't think the ALJ was saying that you don't have to worry about the postural limitations. I believe the ALJ was saying, and what the regulation is saying, is that sedentary work does not involve sufficient postural movement that you need to accommodate it additionally. So it's not that the ALJ said, oh, I don't have to worry about his postural limitations as if they are not there. It is that sedentary work does not require enough postural movement that I need to address it any further than simply limiting this person to sedentary work. So this court has already cited in other cases that this type of evidence is relevant to a claim of debilitating back pain. Then the question becomes, is it such evidence that a reasonable mind might consider is adequate to support a conclusion? And here, this court conducts a de novo review of these cases. But if you wanted to look for a perhaps reasonable mind that looked at this very specific bucket of evidence and concluded that it was sufficient to support the residual functional capacity finding, I would direct the court to magistrate judge's ruling. Cases that come up to this level of court don't always tee up so perfectly where the district court has addressed the facts at issue and then concluded that they are indeed substantial evidence. This case, however, does. And the commissioner would argue that that is persuasive evidence that the substantial evidence standard has been met here. The ALJ is not required to call a medical expert. It is the ALJ and the ALJ alone that determines the residual functional capacity assessment. So that the ALJ called an expert and then concluded that that expert was not sufficiently prepared does not mean that the ALJ is required to call another expert. It doesn't mean that the ALJ has to somehow rely on that expert. It means simply that the ALJ, if there is sufficient evidence to reach a decision, can reach such a decision, and that's what happened here. In terms of the subjective symptoms analysis, the ALJ applied the correct standard. The ALJ cited the correct standard in the decision. Wolven has pulled some language from the ALJ's decision where the ALJ was talking about making observations about the evidence and argues that that is the standard that the ALJ applied. That language that the ALJ used, which was that the evidence failed to fully substantiate Wolven's subjective symptoms, was not something the ALJ said, okay, and this is the standard. Plus, if the ALJ really required that the evidence fully substantiate the subjective symptoms and found that they didn't, again, he would have thrown them out and found that Wolven could do heavy work. But that's not what happened. Substantial evidence supports the ALJ's decision here. It's a question of weighing the evidence. And the ALJ weighed all the evidence. Accordingly, the decision should be affirmed. If there are no further questions, the Commissioner will rest.
Thank you very much, counsel. Case is taken under advisement, and the court will be in recess.